Professor Matthew Kramer, you hear us?
Yes, I can hear you perfectly well. I can't currently see myself, but I can, which is fine. I mean, I don't really want to see myself, so, but I can see you folks and hear you.
Yeah, we can see you and we can maybe. Alguém me ajuda aqui a aumentar o volume? Eu tenho medo de tirar isso aqui e interromper. We
Now
just need to.
I can see myself in a small box here, so that's fine. Anyway, yeah.
We're just trying to raise your volume here. Yeah, now, yeah. I think now we can hear you a little better. And if you could just say hello again, Professor, so we know we can hear you properly.
Hello again.
Yeah, now that's good. Yeah, fantastic. Professor Matthew Kramer, it is so very nice to see you again. And now officially at the University of São Paulo. Is that okay by you if we start? I mean, do you need to check anything?
Am I able to share the screen or not? I haven't used this before.
Yes, you are.
I can certainly do it in Zoom, but I haven't.
There is a mark down by your screen. It will probably say something like present now. It is located next to a raise hand mark.
Yeah, right. It's not allowing me to do this. There's the option of select. Oh, I see. Okay, right, I see. There we go. That's right.
Essas três.
Right. Não tá autorizando a
Não. Ah, não?
Yeah.
Are you seeing this?
Yes, we can see. We can see.
Okay. I can't see you folks at the moment, but that's fine.
No, that's perfectly fine because probably you just see your own screen.
Yes.
I can signal you with my audio should anything happen.
That's fine. I don't care whether I can see myself or not, so that's fine.
But you look
again, but
you look very nice, Professor, and I hope you're going well with your recovery. And
yeah, it still has quite a way to go, but it's definitely proceeding in the right direction.
You look mighty fine. I can assure you that. Let me just introduce everyone. Well, welcome everyone. You have quite an audience here, Professor, and we're broadcasting live on YouTube as well, so people will be able to see that afterwards. I have a few introductions here to make. So we have, of course, with us today now officially, everyone knows that already, but Professor Matthew Kramer is a fellow of the British Academy. He's professor of legal and political philosophy at Cambridge University and a fellow of Churchill College, Cambridge. And he's also the director of the Cambridge Forum for Legal and Political Philosophy. We have also here to debate with us today Professor Marcos Engano, full professor of ancient philosophy at the Faculty of Arts of the University of São Paulo. And we have, of course, Professor José Reinaldo de Lima Lopes, full professor of jurisprudence and legal history at the University of São Paulo Faculty of Law. And now, of course, Professor Kramer, I thank you very much indeed for sharing your afternoon with us. We are all eager to hear you, to learn from you, and warm welcome from all of us here at the University of São Paulo, and the floor is yours.
Right. Well, thank you very much. I'm very pleased to be with you, and I'm grateful to you for the invitation and also for taking the time and trouble to arrange this talk. I should, at the outset, I feel I need to mention this, apologize for my appearance, especially if I turn this way. You'll see that there's still quite a bit of bruising and discoloration on my face, though those aren't the main injuries. Those are superficial. There are other injuries that I incurred as a result of a few mishaps over the course of a couple of weeks. But I am now recovering. So anyway, it won't affect this talk at all, but I felt I should mention that since it's pretty evident from my appearance. I am talking today in compliance with what Gilberto preferred on the topic of impartiality the paper on which this talk is based is called Impartiality in a System of Governance. And the notion of impartiality is a complex notion, and it therefore figures in three quite different contexts in political and moral and legal philosophy. It's especially important, I think, in political and legal philosophy, but also in moral philosophy in somewhat different ways. This ideal of I'll call it an ideal. It could just as well be called a property, but I'll call it an ideal of impartiality, as I've said, is salient in at least three. I'm sure there are others as well, but at least three main contexts, which I will recount here and explain what impartiality is in each of those contexts. Because as I've already stated, impartiality is a complex notion, a complex property, and it can therefore be realized or manifested in different ways in different settings. And that indeed turns out to be the case in the three main settings that I will describe, that I will delineate here. And I'm going to talk about the rule of law and the role of impartiality in being partly constitutive of the objectivity of law. The distinction between the right and the good, or the distinction between accounts of justice and accounts of what the good life or what is valuable or worth doing. That's a distinction that figures very prominently in political philosophy in the present day, especially, though it goes back much further. And then finally, freedom of expression, freedom of speech. And freedom of expression, of course, is a major topic both in political philosophy and in legal philosophy. The objectivity of law, the rule of law, again, is a major topic in both of those areas. I will be talking about it mainly from the perspective of legal philosophy, but the other two contexts, which I will be recounting here, are more in the domain of political philosophy than of legal philosophy, though they are also in legal philosophy. So let's start then with the objectivity of law as a property of the rule of law. Well, objectivity is realized in several different dimensions, which I discuss at some length in a book I published in 2007 entitled Objectivity and the Rule of Law. So objectivity is itself a complex phenomenon, but one aspect or dimension of it would consist in impartiality. And this is in many respects a procedural conception of impartiality with which I'm beginning here, because it concerns different characteristics or features of decision makers that are ideal for them, in the sense that their exhibiting of these characteristics or features will endow their decisions with objectivity of a certain type. And so this is an impartiality of a certain type. So this is impartiality as disinterested, you can see here on the handout, as I'll scroll down a bit just to keep what I'm talking about near the top. This is impartiality as disinterestedness and open-mindedness. Now, when I refer to disinterestedness, that in English, disinterested is not equivalent to uninterested. So it doesn't mean that somebody doesn't care about some issue. Rather, to say that someone is disinterested means that he or she has no direct stake in how an issue is decided. That is, there's no personal stake that is at issue there. And impartiality as disinterestedness then would consist in a lack of partisanship, that is, favoring of one side over the other, even before a decision on an issue is contemplated. And it would amount likewise to no personal stake in the matter. That is, one will not benefit oneself in any non-trivial way from the decision that is to be reached. And likewise, one's relatives and friends do not stand to benefit from the decision that is to be reached. And insofar as that property of disinterestedness is operative, then we have a key component of impartiality as I'm currently discussing it. But there is another major component as well, and that's open-mindedness. So it's not only the case that someone must not have a direct stake, or someone's relatives and friends must not have direct stakes in how a matter is to be resolved, but also that the decision maker, the people entrusted with the relevant decisions, are not biased or favored against one party and to the benefit of another party or set of parties who will be affected by the decision. And this is what I'm calling open-mindedness. That is, that just as partisanship is inimical to the realization of impartiality, so bias is inimical to the realization of impartiality. That is, favoring one side over the other in advance of even contemplating a decision. And that likewise would undermine the impartiality of the decision that is to be reached. So impartiality in the sense I'm currently discussing would require these two properties to be realized. And so impartiality in this sense, as I've already said, is to be contrasted with bias and partisanship, but also with impetuousness and whimsicalness. By impetuousness and whimsicalness, I just mean that someone plunges in and decides a matter without having considered sufficient evidence or any significant relevant evidence. And likewise, whimsicalness would be similar here. That is, it would mean deciding things on the basis of one's hunches or caprices or whims, rather than on a considered contemplation of the matter that is to be decided. And insofar as one's decisions are slanted through rashness or hastiness, impetuousness, or whimsicalness, that is capriciousness, then again, they are not impartial in the relevant sense. They're injecting elements of the decision maker's subjectivity into the decisional process. And that is at odds with impartiality, because, as I say here, impartiality can be alternatively designated in this first sense as detachedness or impersonality. That is, someone is detached from an issue in the sense of not having any direct stake in it and not being biased toward any of the parties and so forth. And likewise, in the sense of not injecting elements of his or her own subjectivity into the decision-making procedure by failing to consider relevant evidence or perhaps any apparent evidence with sufficient care. And this dimension of objectivity as impartiality, pertains most obviously, perhaps, to the processes through which laws are given effect. I'm talking now specifically about legal context. Much the same would be true in moral context, but I'm here focusing on legal context specifically for this first main setting. And laws that are administered by administrative officials or by adjudicators, by executive officials or judges, when the laws are given effect, impartiality is a crucial desideratum of any processes by which they're given effect. That is, insofar as the processes of decision-making are not characterized by impartiality as disinterestedness and open-mindedness and careful consideration of issues, then the impartiality and therefore the objectivity of law in that application is undone. But similarly, to a lesser extent, and to a less evident extent, the enactment of laws by legislatures or by other bodies or individuals who are authorized to create general laws, but the most obvious example of this, of course, would be a legislature. The decisions that go into or constitute the enactment of a law, whereby people propose certain measures and deliberate over the measures and then vote on measures and so forth, that those procedures as well should be impartial, though there's a qualification or caveat here that has to be attached. Because in a liberal democracy, one of the roles of legislators, especially in an elected legislature, there are, of course, other lawmakers, such as administrative agencies who are set up by legislatures to promulgate general regulations and so forth. But when it comes to an administrative body of that sort is not elected. So what I'm about to say does not apply to that sort of institution. But when we're talking about elected legislatures, then a key role of the members of such a legislature in any liberal democracy is to represent constituents. That's not the only role. It's in many contexts may not be the most important role, but it does have a role to play in any liberal democracy, because otherwise representative democracy, in the sense that people vote for legislators whom they prefer over other candidates, otherwise representative democracy would be really quite shallow. And so a caveat has to be attached here to the notion that impartiality as detachedness and impersonality is a property of the enactment of laws, or an ideal of the enactment of laws. It is an ideal of the enactment of laws. That is, ideally, the laws would be enacted in the ways in which they would if the legislators were fully impartial. But still, given that there is a role to play in any liberal democracy for a representation of one's constituents, there is a caveat attached here that isn't applicable to the processes by which laws are given effect. Laws that are given effect by administrative officials the officials must strive for strict impartiality. With the legislators, the ideal of impartiality here is somewhat less strict, in the sense that they must strive for impartiality insofar as their doing so is consistent with their serving the representative function that a legislator is called upon to play in a liberal democracy. So that's impartiality as an ideal or property of the rule of law, and an aspect or dimension of the objectivity of law. And one point to note here, which is what I'll close this discussion of the first main context here, is that impartiality in this sense is a scalar property, by which I mean that it can be realized or achieved to varying degrees. And so there's an ideal of perfect impartiality, but that ideal is generally not attained by most officials who operate systems of legal governance, whether legislative or administrative or adjudicative. Usually, though not always, but usually the ideal of impartiality is realized to varying degrees. In many respects, the higher, the better, but still realized to varying degrees. And that's something that should be recognized clearly, because impartiality in this sense is a scalar property. It can obtain to different degrees. It can be realized with different levels of success. All right, well, that's the first main context in which the ideal of impartiality is salient and of great importance in legal philosophy. As I've said, I've concentrated here on legal impartiality, legal objectivity, even though most of what I've said here would also be applicable to moral impartiality, moral objectivity. Not everything that I've said would be transferable to that domain, but much of it would be. But here I've been focusing on legal impartiality, legal objectivity. All right, so we now move on to the next main focus here, and that is that in liberal political philosophy, liberal democratic political philosophy, during the past several decades as well, though again, the ideal that I'll be discussing goes back much further to the early modern pioneers of liberal democracy. But still, I'm focusing here on, say, the past half century, 5 or 6 decades in particular. And during that period, the ideal of impartiality as neutrality among reasonable conceptions of the good has loomed large. And by reasonable conceptions of the good, what do I mean? Well, a conception of the good would be a conception of what is valuable in life, what is worth doing, what is worth devoting one's time to, what is worthwhile, in other words. And even more strongly, it can be a conception of what is excellent or conducive to human flourishing. So that's a conception of the good, as philosophers like John Rawls discuss it, but countless others use that phrase as well. But Rawls is the one who gave it greatest prominence somewhat over half a century ago. And that would, conceptions of the good then are to be understood as I've just indicated. A reasonable conception of the good is a conception of the good that is in accordance with the basic values of liberal democracy. And foremost among those values would be the freedom and autonomy and dignity of individuals and the fundamental equality of persons. Those are Rawls, largely Rawls's phrases. I've adapted them slightly. So those would be the basic values, are certainly foremost among the basic values as these liberal political philosophers understand them. And the reasonable conceptions of the good then would be conceptions of the good that are in conformity to those basic values. But there are innumerable conceptions of the good that are consistent with those basic values. So this constraint of reasonableness does rule out quite a few conceptions of the good, any conceptions that are inconsistent with the freedom and autonomy and dignity of individuals and with the fundamental equality of persons. So there are conceptions of the good that would be clearly at odds with those values. And for example, someone who thinks that wife beating is a worthwhile activity, that's obviously grossly at odds with the values of liberal democracy, and therefore does not qualify as a reasonable conception of the good. It's not a conception of the good in regard to which a system of governance must remain neutral in the relevant sense. So we're not talking about those illiberal conceptions of the good. We're talking about conceptions of the good that are in conformity to the basic values of liberal democracy. And nonetheless, there are countless such conceptions of the good. To some extent, they can be combined, but they're very much distinct as well, and will often be found in isolation from one another. So conceptions of the good, then, reasonable conceptions of the good, then, are such that, according to contemporary liberal democratic philosophers, political philosophers, conceptions of the good are such that a system of governance must remain neutral among them. In other words, they're contending that a system of governance cannot enact laws or adopt policies that are designed to favor certain reasonable conceptions of the good over others, or that take as a central means for the attainment of some objective to be the favoring of some reasonable conceptions of the good over others. And so there's no problem with favoring reasonable conceptions of the good over unreasonable conceptions of the good. That's not a problem at all for any system of governance. On the contrary, it ought to be doing so. But nonetheless, these reasonable conceptions of the good are such that any system of governance is morally obligated to remain neutral among them, in the sense of not favoring certain reasonable conceptions of the good over others by designedly according certain privileges to some conceptions of the good, or by using the bestowal of certain privileges on conceptions of the good for the attainment of some other objective. And so, as I say in the second paragraph here, the controversies between liberal neutralists, such as John, I should go back, by the way, let me just say, as I say here, this ideal of neutrality among reasonable conceptions of the good is certainly given voice in classical liberal democracy, people like John Locke and so forth, but its present day prominence, I think, is clearly due chiefly to the writings of John Rawls, and also to a lesser extent to the writings of Ronald Dworkin. They are the two philosophers who in the 1970s brought this notion of neutrality among reasonable conceptions of the good to greatest prominence. And it's remained highly prominent ever since then. I don't discuss this here, but it's a debate between liberal, or a set of debates, a multifaceted set of debates between liberal neutralists and perfectionists of various kind. I talk here about liberal neutralists and their opponents. By the way, complicatedly, I myself am both a proponent of liberal neutralism and an opponent of it. If you're interested in seeing how that can be the case, then my 2017 book, Liberalism with Excellence, should make clear for you both in what sense I'm a proponent of liberal neutralism and in what sense or senses I'm an opponent of it. But here we're focusing on controversies between liberal neutralists such as Rawls and Dworkin and their perfectionist opponents. So I'll mention just a few here, such as Thomas Herka, Joseph Raz, and Richard Arneson, and any number of others who have opposed liberal neutralism, but have in turn espoused doctrines that in one way or another emphasize the legitimacy of favoring certain reasonable conceptions of the good over others, because it's clear enough that some conceptions of the good are incorrect in the evaluative importance or the favorableness with which these conceptions assess certain activities. So if someone, for example, enjoys mud wrestling and feels that a really valuable use of one's time is to engage in mud wrestling and watch mud wrestling, as opposed to worthier activities that someone might undertake, then at least if the preference for mud wrestling is a strong one that leads to a person devoting a great deal of his or her time to that activity, then that conception of the good, though it is consistent with the basic values of liberal democracy, nonetheless, evaluatively, it really is mistaken in the importance or worth that it attaches to mud wrestling, either as a spectator or as a participant. So there are clearly reasonable conceptions of the good, reasonable in the relevant sense here, which are nonetheless evaluatively mistaken. And the opponents of liberal neutralism maintain, liberal neutralism here being a type of impartiality, the type of impartiality that is realized in this context, insofar as a system of governance does remain neutral among reasonable conceptions of the good. The opponents of liberal neutralism, whom I'm calling perfectionists, as they're very often called, maintain that the mistakenness of certain reasonable conceptions of the good is something that can be the basis for legitimate governmental interaction taken to discourage or disfavor the reasonable conceptions of the good that are nonetheless evaluatively badly mistaken. And so those controversies then, as I've said, have been prominent for the past 5 or 6 decades. And to understand them fully, we should grasp something I've already indicated, which is that the concern here is not just with the underlying objectives or goals of a system of governance, but also with the means that have been selected for the attainment of those goals. So suppose, for example, that a system of governance is pursuing the objective of maintaining social order and civil harmony. And suppose that in order to achieve that goal, the system of governance chooses to favor one religion over other religions that are practiced in the relevant jurisdiction. And it does so by designating that one favored religion as the established religion, that is a religion that has an officially recognized status, in contrast with each of the other religions that practiced in the society. And the system of governance does this not because it regards the favored religion as inherently worthy, but simply because, given the empirical circumstances that are known to the system of the officials in the system of governance, they judge that according a privileged status to this religion, it will be a highly effective means of realizing the desideratum of social peace, social order, civil harmony. And in that context, the objective being pursued, social order, civil harmony, is not itself at odds with the ideal of impartiality as neutrality among reasonable conceptions of the good. That objective, that underlying objective, is impartial in the relevant sense, that is neutral among reasonable conceptions of the good. But it nonetheless is what the system of governance has done overall through adopting a certain means to attain that objective is clearly inconsistent with the realization of impartiality as neutrality among conceptions of the good, because it has explicitly favored one religious doctrine or one set of religious doctrines over others. So that's why it's important, or that's an illustration of why it's important to recognize that not only the objectives being pursued, but also the means that are chosen to attain those objectives are what must satisfy this ideal of impartiality as neutrality among reasonable conceptions of the good. So that's the second area that I'm discussing in which the ideal of impartiality figures prominently in present-day liberal democratic political philosophy, and especially in the debates between Rawlsians and their opponents. And their opponents aren't only the perfectionists, but the perfectionists have been especially conspicuous in past decades, at least. Certainly in the 1980s and 1990s into the early 2000s, perfectionism was still widely espoused of the type that I'm discussing, whereby certain reasonable conceptions of the good could legitimately be favored over others. That's the distinctive perfectionist claim. And that type of perfectionism is the chief nemesis for the Rawlsians and also for followers of Ronald Dworkin, who adopt his somewhat different approach, but still clearly cognate approach to these matters of impartiality as neutrality among reasonable conceptions of the good. So we now come to the third area then that I'm going to discuss, the third and final area. And that is in the philosophy and indeed the constitutional law of freedom of expression. The ideal of impartiality, again, has been salient here in the sense that a system of governance should remain impartial with regard to expressive or communicative activities in a sense which, again, I will discuss. And this sense, just as in the second context that we've just been examining, where the Rawlsians are arguing for neutrality among reasonable conceptions of the good, impartiality in this third sense is also frequently designated as neutrality. So I will use that terminology, but you should recognize that what I'm talking about here is a type of impartiality just as much as the first two types that I've pondered. So impartiality in this third context then is something that has been developed both in the philosophical literature on freedom of expression and in much of American constitutional law is the only body of constitutional law on which I'm qualified to comment. But I'm sure American constitutional law isn't unique or alone in this respect. But nonetheless, I think it's especially salient. It has been especially influential globally. And so it's also the only area of constitutional law I know well, even though I've lived in England for a long time. So it's the only area of law that I'll discuss, but and I'm not going to go into any detail on it. But in American constitutional law, the famous First Amendment to the U.S. Constitution, an amendment adopted shortly after the main text was approved, this amendment guarantees a number of different liberties, including freedom of speech or freedom of expression. The First Amendment specifically protects expressive activities against congressional enactments, but subsequent decisions by the US Supreme Court and other adjudicators in the United States have extended this constitutional protection to measures that are taken by state legislatures or by administrative bodies, including the police, for example. So the type of impartiality or neutrality that I'm discussing here then is something that is operative in regard to any enactments, legislative enactments in the United States, but is also operative in regard to administrative procedures, adjudicative procedures. And so it's a really wide-ranging constraint or requirement. And as I've said, usually the terminology of neutrality is used, so that's what I'll be using here. But the main kinds of impartiality that are required here under the principle of freedom of expression, and I'm talking now about the moral principle of freedom of expression, though most of what I'm saying is also applicable to American constitutional law with reference to the First Amendment to the American Constitution. But I'm talking now here specifically about the moral principle of freedom of expression, which, again, philosophical discussions of the moral principle of freedom of expression have been quite heavily influenced by American constitutional law. It would be crazy if philosophers weren't attuned to American constitutional law, given what a vast array of resources it offers, both the distinctions that are drawn within it and the doctrines that have been developed and the sorts of problems that have been contemplated therein. So any knowledgeable philosopher will be attuned to American constitutional law on these matters. But I am now talking about the philosophical principle of freedom of expression, the moral principle of freedom of expression. And the main types of impartiality required under that principle are communication neutrality, subject neutrality, viewpoint neutrality, and speaker neutrality. Subject neutrality and viewpoint neutrality can be grouped together as content neutrality. So what do I mean by each of these types of neutrality or impartiality? Well, communication neutrality would be the broadest of these ideas. That is, it would maintain that any communicative activities are legitimately open to legal restriction or prohibition or penalties only insofar as those communicative activities are constitutive of communication independent misconduct. Now, by communication independent misconduct, I mean misconduct that can be perpetrated either communicatively or through non-communicative action. And therefore, if both of these broad categories of the misconduct in question are punished with equal severity, then the type of misconduct that is being restricted or penalized is communication independent, in the sense that it can occur either through communicative activities or through non-communicative activities. And a prohibition or restriction or regulation that respects or abides by this constraint of communication neutrality is therefore communication neutral itself. That is, that such a restriction or prohibition or regulation does not single out certain conduct on the ground that it is communicatively wrong. It would proceed against certain conduct because it is wrong to cure, whether it is communicative or non-communicative in its specific manifestation. And so let me give a quick example here that I think will help to clarify the point. Suppose that, to take a familiar instance, at least it's familiar to any Americans, I imagine it's familiar beyond the boundaries of the United States. Oliver Wendell Holmes, just over a century ago, in a US Supreme Court opinion, broached the scenario in which a man maliciously shouts out "fire" in a crowded theater. Now, remember, at that point, somewhat over a century ago, it's quite likely that the lighting wasn't electric, or at least not fully electric, and so may have involved some flames and so forth. And in these circumstances, in a darkened theater, to shout out fire maliciously in an attempt to induce a public disturbance, an instance of serious public disorder that would result quite probably in serious injuries, if not deaths, and in damage to property and so forth. This sort of conduct is clearly communicative in the sense that the man shouted out fire and relies on the awareness of his or her fellow members of the audience to recognize what this means. So it's a communicative instance of conduct, but the misconduct which it constitutes, the misconduct of which it is an instance, is instigating a serious public disturbance or undertaking to bring about an instance of serious public disorder. And that sort of misconduct can be perpetrated either communicatively, as it was in this instance, or through various non-communicative means. For example, a man might have set fire to a portion of the theater, or the man might have shot a gun or done something else to cause people to panic and to stampede. And so this sort of misconduct, which was constituted by the shouting of the word fire in the context in which it occurred, this sort of misconduct is communication independent wrongdoing. That is, it can be perpetrated either communicatively or non-communicatively. And therefore, an appropriate restriction or prohibition on such conduct can itself be communication neutral if it does not single out the communicative instances for unique punishment or harsher punishment than the non-communicative instances of the same type of wrongdoing. So that's an example of, it's not the only example. I would need to go into other examples to cover the matter fully, but I have only limited time here. So that's one example of communication independent misconduct that can properly be prohibited and punished as communication independent wrongdoing. Subject neutrality means that a system of governance cannot legitimately favor some topics, some subjects over others by permitting discussions of certain topics and by forbidding or somehow disadvantaging discussions of other topics. And if a system of governance is subject neutral, then it will not single out certain subjects as matters that can, as a matter of law, be permissibly discussed in public, and prohibiting discussions, proscribing any discussions of certain other topics. And so suppose, for example, that a system of governance allows advertisements to be placed on certain structures, perhaps the sides and backs of the municipal buses that are operated in some locality. And the system of governance elects to prohibit discussions of certain topics, such as religion or politically controversial matters, and allows discussions of other topics, other subjects. Well, that's clearly a deviation from subject neutrality. The system of governance is not being subject neutral. It is favoring certain topics, certain subjects, certain foci of discussion over others. And in so doing, it is departing from the ideal of impartiality in this context of freedom of expression, where the ideal of impartiality is realized as these different types of neutrality on the part of the system of governance. Likewise, even more glaringly at odds with the realization of impartiality as neutrality would be viewpoint a violation of viewpoint neutrality. Viewpoint neutrality refers to a situation in which a system of governance does not take sides in the debates which it permits in public fora. And so if the system of governance refrains from taking sides in those debates by favoring some viewpoints over others, for example, suppose that a system of governance allows the placing of advertisements by partisans of the Labour Party in the United Kingdom or by partisans of the Conservative Party in the United Kingdom, but not by rival parties, not by any opposing parties. Well, that would clearly be a violation of the constraint of viewpoint neutrality. It would be privileging certain viewpoints over others and allowing expressive activities to be undertaken by people who adhere to certain viewpoints and by disallowing the undertaking of communicative activities by people who adhere to alternative viewpoints that are disfavored by the system of governance. So that's another type of neutrality required as impartiality required in this context of freedom of expression. A final type that I'll mention here is speaker neutrality. And this would mean that even if all topics are permitted to be discussed in some arena, in some public forum, and even if all viewpoints are permitted to be expressed, to be given voice in this public forum, a system of governance might nonetheless prohibit certain individuals from speaking. It allows their views to be aired, but it does not allow them to speak in public. And this was exactly the case in the late 1980s through the early 1990s in the United Kingdom, when members of Northern Irish terrorist groups it was forbidden for broadcasters such as the BBC, but also other broadcasters, to air the voices of terrorists, that the terrorists were not allowed to speak in public and specifically through broadcasts. And likewise, the broadcasters themselves were prohibited from seeking to air those voices. So the words of these terrorists could be presented through imitations by actors, but the terrorists themselves were not allowed to speak. I thought at the time that this was a silly restriction, and I continue to think that it was a silly restriction, but it's also clearly in violation of the principle of freedom of expression because it is inconsistent with the requirement of speaker neutrality. Now, I'm not going to take up the final paragraph here. I've already spoken for quite a while, so I'll just say if I were to conclude on this final paragraph here, what I would be discussing is the justification for this requirement of impartiality as neutrality in the context of freedom of expression. And it clearly does require a justification. If I had time, but I don't, but if I had time, I would go into the matter of the justification for the principle of freedom of expression generally, and for this requirement of neutrality or the set of requirements of neutrality more specifically. But the point is just to note here, without going into any of the details, that a justification is clearly required, because adhering to these constraints of neutrality, impartiality as neutrality in regard to communicative activities, the burdens of adhering to those constraints can be considerable in certain contexts. And so the justification for imposing those burdens on a system of governance has to be furnished. And I have indeed sought to furnish such a justification in my 2021 book, Freedom of Expression as Self-Restraint. But I won't go into that matter here. Instead, I'll conclude with that matter. So thank you very much. I will stop sharing my screen here. I think that, yeah. I think I've stopped. Right. Yeah, there we go.
Yes. Hear the applause, Professor?
Yeah, yes. Well, I didn't actually hear it, but I saw you applauding. So thank you very much.
Good. That's very good. I still believe to this day that your clarity is second to none. So I thank you for that. It was a great honor to have you here. It was a great talk indeed. Without further ado, I'm going to bring into our discussion Professor Marco Zingano. I believe he has quite a few comments to make. So, Professor Zingano, thank you very much. And thank you, Professor Matthew. Thank you very much.
Well, first of all, thank you very much, Professor Kramer.
Thank you, folks.
Is that working? It's okay?
Can you hear Professor Zingano quite well? Yeah?
Okay, excellent. So it was a very illuminating talk and very clear. And there are several aspects of it that we can discuss. They are worth discussing in several directions. Well, I listen to your talk now. I would like to focus on just one point and see how, and I would like you to elaborate on this topic. Is how central do you think the notion of impartiality is? Well, you examine it under three aspects, three dimensions: the rule of law, the conceptions of right and wrong, and then the third one was freedom of speech. It was very, very interesting. But I was wondering if one think of impartiality in the sort of fabric, uh, the language of morals, of the law, how central is it for you? So you brought some other notions and connected them to impartiality. For instance, empathy, neutrality. When you were discussing the conceptions of right and the good, how to well, the idea of staying neutral in order not to make one of these conceptions to go over the other one, but there's some idea of helping them to flourish all these reasonable conceptions of right and good. So there are a series of other notions that are connected to impartiality. And I would like to know, how do you take this? So how central is the notion of impartiality to your thought, whether impartiality goes to the core of our notion of freedom or morality. So this will be my main question. There are other several aspects, but I think I will stick to this main point. If you could elaborate on it, I would appreciate it.
Okay, should I speak now or should I wait for the other commentary?
It's really up to you, Professor. You can either respond to Professor Zingano now, and you can either listen first to what Professor José Reinaldo has to say. So it really is up to you. Okay,
I think I'll speak now because it's easier for me to keep in mind what's been said if I'm speaking directly after it's been said. I would say, no, it's a very good question. I said near the outset that impartiality is a complex ideal, a complex phenomenon. And obviously, therefore, it can be realized in more than one way and in more than one setting. And nonetheless, there is something recognizably in common among the settings, I think, and that is that impartiality, of course, doesn't denote the failure or abstention from taking part in a decision. But what it does denote is not being partial in the sense of not being partisan And here I'm invoking the notion of partisanship in a very broad sense. I invoked it at one point on the handout and in my paper, but here I'm using it in a broader sense. So I don't just mean a lack of bias, but I mean a lack of favoritism that is not itself integrally related to the decision that is to be reached, rather than to features of the parties involved, or features of the situations involved, or features of the conceptions of good that are involved, and so forth. And so, of course, one needs to reach a decision in one direction or the other. And so at that point, one is not impartial in the sense of abstaining from taking a position at all. But nonetheless, one is impartial in the sense of not being partisan, or not being partial to, that is, favoring in some way that is unfair or inconsistent with applicable moral principles, the parties and activities and conceptions of the good that would be under consideration. And impartiality, as I understand it, would consist above all in that sense of not favoring certain parties, certain activities, certain conceptions of the good in ways that are not integral to the decision itself that is ultimately reached. That is, of course, one favors certain parties or certain activities by reaching a decision on a dispute or some other conflict among them. But nonetheless, if one is impartial in doing so, one will have proceeded by an assessment of the different considerations on each side of a matter. There may be more than two sides, and then arriving at a judgment on general evaluative grounds and deontic grounds, rather than on any leaning toward or partisanship toward certain types of parties, certain types of activities, certain types of conceptions of the good, or of communicative ideas, and so forth. And impartiality, as I understand it, would consist above all in that sense of not being tendentious, not being skewed in a certain direction by any of the factors that I went through in my talk. And so the absence of skewing, I think, is really what I'm talking about, is impartiality. And so a decision is impartial insofar as it is not slanted or skewed in a certain direction by factors that aren't themselves integral to the decision. So that's broadly what I would have in mind. But obviously, that very general sense of impartiality can then be realized in quite different ways, ways that are consistent with one another, but that aren't reducible to one another.
Thank you, Professor Kramer. And now let me just reintroduce to you Professor José Reinaldo, and he has a few comments to make as well. So please, Professor José Reinaldo.
I'm not hearing him.
Yeah, I'm sorry. I apologize. Okay, can you hear us now, Professor Kramer?
I can hear you, certainly.
Okay, thank you.
Can you hear Professor Reinaldo?
Can you
Yeah,
hear
I can hear you fine now. Thank you.
Okay. My apologies. It was my fault.
So thank you. Thank you for being here with us this afternoon, Professor Kramer. Thank you, everybody who's present here, people who are listening to us and watching us on YouTube. Thank you, Zingano, again. Thank you, Gilberto, for organizing the session. I was taking a lot of notes when you were speaking, and I read your paper, but I will concentrate, just as Zingano did it, on one aspect. Just, I think your paper and your lecture were very thought-provoking, So lots of things would have to can be discussed. But I will take just one point. I think I agree with you when you talk about impartiality at the beginning of the paper, referring to decisions by law courts, judicial decisions. Of course, my point, and I think that's your point, the very idea of impartiality is the definition of a judge. The judge is the third party who must have nothing to do with the object of the dispute and with the parties who are disputing. Nemo iudex in re sua. My question, it's more like a provocation, just to have you react and elaborate. I don't think we can have a legislator of whom we would say, nemo legislatorem in re sua. The legislator is at the same time part of the society for which he or it or she will be legislating. So my question would be, how do you introduce impartiality in the legislative process? I know you did that in a way, but my question, my doubt, my thought is, it's easy to see impartiality in the justification of a judicial decision. It is, for me, more difficult to see impartiality in the justification of the enactment of a statute, even of a constitution, but let's talk about the statute. So I also think we can use the idea of impartiality in legislation, but I would like to hear you elaborate on this idea. How can you call a legislator impartial? I'll give you one example before I finish, or two examples. First, take the case of, in Brazil, consumer law or labor law. These are statutes and codes enacted to make difference. That is, you enact a code, the case of labor law and consumer law, to overcome the equality provided for in the civil code. You will not be able, by law, you will not have the right to treat a consumer and the producer equally. So the law comes in a partial point of view, from a partial point of view. That's one example. Another example would have to do with anti-discrimination law in general, which is also enacted, and the justification for the enactment is the acknowledgement of differences and the introduction of these differences, which are social existing differences, into the legal system. So it's more like a provocation. I know you have a good answer for that, or at least we can have a good talk about that, but that's my point. Thank you very much.
Are you hearing me now?
Yes, perfectly.
Yeah. Right. Okay. Yes, it's a good question. I would respond as follows: that you're clearly correct in saying, and as I said in my talk, but also as you correctly said, that the ideal of impartiality is not realizable in the same way, and indeed not properly realizable in the same way in the legislative context in which it is at least potentially realizable in the context of administering or applying the law by judges or by administrative officials. And I fully agree with that, because the members of the legislature are serving representative roles. It's not their only roles, it's not always their most important roles, but they are serving representative roles. And that's why I say that the ideal of impartiality in that context is an ideal only insofar as it is consistent with the fulfillment of that representative function. But nonetheless, I think one can easily think of examples where the ideal of impartiality is precisely what is being contravened in ways that aren't required or demanded by this representative role. And so when there are concerns about the extent to which lobbyists introduce considerations into legislative enactments, legislative decision-making that are skewed in their own favor, and not because the lobbyists themselves have any important representative demands to place on the legislature, but simply because in various ways they are making it attractive, perhaps financially or perhaps through other inducements, to vote in favor of certain legislation and against contrary legislation. And likewise, in regard to concerns about so-called interest groups or political action groups and so forth, in devoting funding to certain candidates and withholding funding from their opponents, the clear expectation of these political action groups in many contexts, at least, is that their favored legislative agenda will be advanced or pressed by the people, the candidates whom they are helping to elect. And in these sorts of contexts, where it's not the representative role of a legislator that is at stake or at issue, but it's instead the role of a legislator in seeking to reach decisions about what sorts of legislative measures should be enacted and what sorts of measures he or she should be voting in favor of. In these sorts of contexts where it's not a requirement of the representative role of that legislature, where his or her constituents in large numbers favor certain enactments, that much a legislator can legitimately take into account and act on the basis of it. But when a legislator takes into account the favors of lobbyists or the funding provided by political action campaigns and translates those into the pattern of voting that he or she adopts, that I think is clearly a departure from impartiality that is not justified by reference to the representative role of the legislator. Now, it may be that this way of favoring certain enactments can't be eliminated entirely, and I would accept that much. That is, the ideal of impartiality, even insofar as it is not at odds with the representative function of a legislator, is nonetheless not realizable perfectly, and I accept that. But that's why I said in that context it should be emphasized that impartiality is a scalar property. It's something that can be realized to varying degrees, and therefore I think that limits on funding, for example, in certain ways at least, certain ways that make manifest the sources of the funding, that such restrictions can be legitimate in liberal democracies, because they serve to ensure or at least to bring about the ideal of impartiality to a degree where that the realization of that ideal is still consistent with the performance of representative roles by the legislators. So that would be a brief response on my part, but you're right, it requires further discussion, clearly.
Thank you, Professor Kramer. Well, I myself, of course, have some questions, but I think I might need to prioritize here some questions from the audience. So if you still have time, Professor Kramer, for maybe a couple of questions.
Yes, I still have about 20 minutes, about 15 minutes, so that's fine.
Okay, so maybe one question from the audience. Martin, if you could help us here with the...
Yeah.
So we're gonna take one question from the audience.
Fine.
I was already lucky enough to discuss it with you, so I'll prioritize people who are here, and then
Então você chega aqui.
they're just checking if. Vem desse lado aqui da mesa.
Yeah.
Pode vir desse lado da mesa para o professor ver até. We're gonna bring someone from the audience here so they can.
Yeah. It's working. It's nice for Professor Kramer to see the audience.
Yeah, so you have quite an audience here that people are watching on YouTube, of course, but they want to see you here as well.
Okay, thank you, Professor Mattew, for your presentation. It was really thought-provoking. My name is Martin. I'm a master candidate here at our law school. And my question for you is about maybe an implication of your argument that I interpret as some sort of criticism of neutralist liberalism, this idea of neutralism, total neutralism between plans of life and conceptions of the good. And my question is about common goods in the sense of goods that we need active cooperation for maintaining and productive. So I think about environment or even tolerance, just to remain in the question of freedom of speech. It seems to me that these goods are previous to personal choices of the good. So what would be your stance or your position about impartiality on these issues? Do you think
Sorry. Go ahead. No, go ahead and finish, please. I'm sorry I interrupted you.
No, it was just a question. How do you see impartiality, your argument of impartiality on these matters? Do you think that you can accommodate neutrality on personal choices such as religion, some sort of ideas that you can express through speech, with common goods, with more active interference from the state and to secure these goods such as environment tolerance? That's it. Thank you.
Right. Thank you very much. In Anglo-American philosophy, these are normally or frequently designated as public goods, but we could just as well talk about them as common goods. And I discuss public goods at some length in chapter 2 of my 2017 book, Liberalism with Excellence. So they are an important matter. But the reason I didn't broach them at all here, apart from sheer constraints on time, is that public goods are not an issue in the debates between Rawlsians and their opponents, because Rawlsians allow that the pursuit of public goods, such as clean air, for example, or to use a couple of examples I mentioned, civil harmony, or you say tolerance. These are all public goods, but precisely for that reason, liberal neutralists readily accept that goods of that sort can legitimately be pursued by any system of governance. And so, of course, their perfectionist opponents concur with them on this, and therefore it's not a point of contention between them. So that's the main reason I didn't mention it. But I think one thing that can be pressed, which I do press in chapter 2 of Liberalism with Excellence, is that I think the category of public goods is wider than the Rawlsians, or at least some Rawlsians acknowledge. Rawls himself, I think, had a fairly accurate understanding of that category, but some more recent Rawlsians, I think, have underestimated the range of goods, the range of desiderata that can properly be classified as public goods. And again, the main reason I didn't mention them at all here is simply that public goods aren't the foci of debates between Rawlsians and their opponents, because everyone accepts that insofar as some desideratum is properly classifiable as a public good, that any system of governance can and should legitimately pursue it.
Thank you, Professor Kramer. Do you still have maybe 5 minutes? How How are we on time?
I still have about 10 minutes or so.
Okay, so we can take maybe, Professor Eduardo Volk is here with us. So we have another question. I would ask the audience, anyone who has questions, please to approach the camera maybe. So Professor.
Thank you very much for it. So Professor Kramer, it was a great pleasure to read your book and now to hear you here speaking with us. It's just a question of clarification. Now, regarding the second area that you discussed in the paper in your presentation concerning Rawls and his tendency to conceive reasonable conceptions of the good in terms of liberal tolerance. That's how you put it, and that's how Rawls put it, right? My question in this is just a clarification question is this. A modern, consistent conception of tolerance requires a objectionable component. Without it, it's not exactly tolerance, right? I am tolerating something. I have a consistent conception of tolerance when it's something that is actually objectionable. Otherwise, it's not tolerance. Now, in terms of a liberal political theory, how can I frame a conception of liberal tolerance that conflates with the very notion of impartiality and neutrality if tolerance excludes neutrality and impartiality? It is different from neutrality and impartiality. Thank you.
Right, good question. That in my 2021 book on freedom of expression, to which I referred a couple of times in my talk, the title of that book is Freedom of Expression as Self-Restraint. And the self-restraint in question is the self-restraint exercised by a system of governance in declining to intervene to discountenance or prohibit certain types of communicative activity that are not prohibitable under the principle of freedom of expression. And self-restraint is actually a notion that I favor over that of tolerance. That is why I generally don't, I sometimes, of course, use the word tolerance, but that is generally not the word that I use most of the time. Instead, I prefer to talk about self-restraint. Now, the self-restraint might be effortless if the communicative activities in question that are permitted are clearly upstanding and clearly commendable. And so the self-restraint wouldn't be tolerance in any pejorative sense in relation to activities of that sort. But nonetheless, there would also, in many contexts, be a requirement of self-restraint in response to much uglier forms of communication that nonetheless are not constitutive of communication independent misconduct. And so quite a bit of what is ordinarily classified as hate speech would be of this type. And that's why I generally write against that, in opposition to the hate speech statutes that have been enacted in the United Kingdom and in most other European countries and a number of South American countries and so forth, and in Canada and Australia, New Zealand. And the United States is one of the very few liberal democratic jurisdictions without such statutes, and that's because the US Constitution would disallow them. But I maintain in that case that the US Constitution is in accordance with the moral principle of freedom of expression, because this ideal of self-restraint is to be exercised not only when the communicative activities are commendable and upstanding, but also when they are ugly, provided that they are not inconsistent with the moral principle of freedom of expression, because they don't constitute communication independent misconduct. And so in that context, the self-restraint that is to be exercised would not be effortless. It would be toleration in a pejorative sense, but that toleration would not be inert or idle. The system of governance in question would also be taking measures to counteract any pernicious effects of the communicative activities which it is allowing. And so that's why I prefer not to, again, use the term toleration even when the communicative activities are rebarbative, because even so, the toleration tends to sound passive, or tends to convey to me a posture of passivity, whereas I have in mind an active posture that nonetheless does not consist in prohibiting or penalizing certain types of communications that are not constitutive of communication independent misconduct, but where the potentially pernicious effects of those communications would be countered in other ways, which I explore in great detail in chapters 5 and 6 of my 2021 book. So, like you, I'm wary of the term toleration, and I do sometimes use it, of course, but it's not generally what I invoke. And indeed, it's not very often a term that Rawls himself invokes. He talks much more often about neutrality and uses various other terms. He does, again, of course, sometimes talk about toleration or tolerance. And tolerance is a virtue or ideal, but it's partly because, as you suggest, it conveys a certain pejorative or negative attitude toward what is being tolerated, but also because I think it can misleadingly convey a sense of passivity, which is not at all what I have in mind when I talk about self-restraint. I think it's a word that is best not used very frequently.
Thank you.
So, Professor Kramer, again, your clarity, like I said, is second to none. Thank you for taking the time to answer a few questions. I'd like to ask now if you have maybe a few concluding remarks, if that's the case, for your final minutes. Already,
Okay.
thank you very much indeed for sharing your time with us.
Okay, well, I would just like to thank everyone involved, especially you, Gilberto. I know you played the central role in organizing this event, but also all your colleagues at Sao Paulo who were involved, and the members of the audience who have attended and asked perceptive questions. So I'm very grateful to everyone who has participated in the organization and or the actual running of this event. So thank you very much.
Thank you. It was an absolute honor to have you here at Sao Paulo. So I'll see you maybe on next time in person, or maybe another event here at USP.
Yeah, I hope I won't be bruised as I am now, but in the meantime.
Fine, I can assure you that. You look mighty fine. Thank you, Professor. I'll see you.
Quel dénouement.